May it please the court. When the defendant in this case entered his plea, he admitted that he was guilty of robbery. To this day, he maintains that he is guilty of robbery. Actual innocence is a narrow claim that applies in one of two situations, or possibly both, I guess. One, the state has convicted the wrong person, or two, the crime never took place. It's an understanding of actual innocence that goes back at least to the United States Supreme Court's decision in the Sawyer versus Whitley case, and possibly even earlier than that. The state's position on further review is that the district court's dismissal of the defendant's second application for PCR was proper for several reasons. Maybe the most important reason being that nowhere in the defendant's petition does he allege that he is innocent or that the weapon he used to commit the robbery was not capable of causing death. In fact, at the hearing on the motion to dismiss, the defendant's counsel admitted that he did not know whether the weapon was capable of causing death.
Yeah, I mean, it looks like reading your brief, you've kind of put your eggs in the no actual innocence basket. Would it be potentially possible to resolve this case on the under 822.8 on the grounds that there was a prior PCR and this very same issue about the weapon not being a dangerous weapon was litigated and resolved, and the court said there was a factual basis for the plea, and the defendant doesn't have, or Mr. Dewberry doesn't have anything new here. It's not like there's new evidence out there. He's just arguing the same thing he lost on in the prior PCR. So couldn't we resolve it on that basis?
Absolutely, Your Honor. The claim that he makes in his second petition is functionally identical to the claim that he made and lost on in the first petition. It's an attack on the factual basis of his plea. And it actually was not really even developed into an actual innocence claim until his motion for reconsideration that he filed after the court dismissed the PCR.
Was 822.8 raised in the district court? I thought the only resistance was there was no actual innocence claim presented, and not that this was litigated previously.
It was raised in the state's motion to dismiss. The state argued that the state actually argued that the whole thing was raised judicata, and then what happened was the district court dismissed only this claim, and because the rest of his claims were ineffective assistance of counsel claims that had not, in fact, been raised before.
Well, in other words, not only was it raised below, but it was the basis for the district court decision below. So why don't we just affirm on that grounds and leave this scope of actual innocence to another day when there's maybe a different test case before us?
You are certainly free to do that. I would be perfectly happy with an opinion that says that. The part of the impetus for the application for further review is that this argument about actual innocence was not addressed in the Court of Appeals opinion, and my understanding of the rules, the fact that the Court of Appeals just got something wrong is not a ground for further review under the rules. But if this court wants to resolve it on that basis, that would be fine. However, if the court is inclined to address the actual innocence issue, I would just say I think it's a fairly straightforward question. This court's decision in the Schmidt case said that the due process violation that results in that claim forbids holding a person who has committed no crime. The defendant in this case is no such person, and we think for that reason, as well as for the reason that Justice Mansfield pointed out, the dismissal of the PCR was proper. Thank you.
Mr. Ogden, thank you as well. Ms. Siebrecht.
Thank you. May it please the court, counsel. I'm Kathleen Siebrecht. I'm up here today on behalf of my client.
Excuse me, Counsel, can you pull the microphone down a little? He's much taller than you.
Exactly. Thank you. I represent Mr. David Dewberry in this matter. We both thank you for this opportunity to be heard today. Here we are. Here's the chance for this court to further define actual innocence. I would submit, not surprisingly, that actual innocence includes Mr. Dewberry's claim.
Well, but tell me, I mean, he had one swing at it in the earlier litigation and failed. Is it exactly the same claim?
I don't believe he did have one swing at it yet. The problem is that no court has ruled that this weapon was actually a deadly weapon. That's what he's asking, is to be allowed to present the evidence whether or not this was a deadly weapon.
Is that really a part of absolute innocence? I mean, we have our lesser included offense law, basically, and if this went to trial, he would have been, the jury would have been instructed on both counts, the first degree and second degree, whatever it set out, and if they found that it wasn't a deadly weapon, he still would have been found guilty of the second degree. The problem is, under absolute innocence, you have to be innocent of the charges, all crimes that you were charged with, and he basically was charged with the second degree because it would have been instructed. So how does absolute innocence, when you look at our cases and the cases from the other states who have it, protect him?
And I don't think that has been defined yet. Under Schmidt, we refer to it as actual innocence, and I believe one of the dissents brought up that issue. Does that include...
I'm the guilty party.
Does that include the defendant having to prove that he did not commit any crime?
Schmidt said all crimes charged, and he was charged with both these crimes under our lesser included law, and you're admitting he was probably guilty of the lesser included one if he went to trial. I mean, so I don't know how Schmidt helps you.
Well, the purpose of Schmidt was to make sure that we don't have defendants sitting in jail who are not guilty of the crimes that they were convicted of. We look at, there's a huge disparity in the sentencing in this kind of a case, whether it's robbery first or second.
I mean, here's something. I mean, if you play out what you're saying, it was a guilty plea, as is going to be the situation in a Schmidt case. And there was a review of it, and there was a determination that the plea had a factual basis. Now, there's been no new evidence in the record. This isn't like Schmidt where there was an affidavit. There's no new evidence of the record. So you're simply saying, well, my client should be entitled to show that even though there was a factual basis, and the court already found there was a factual basis, as a matter of actual facts or truth, it really wasn't a dangerous weapon. And that wouldn't that totally turn guilty pleas upside down, because now a factual basis for a guilty plea would no longer be enough. The court would have to find to some higher level of proof that the defendant was actually guilty of all elements of the crime. That would really turn guilty pleas upside down, wouldn't it?
And I would dispute that there was actually a factual basis in this case. I don't believe that my client's admission during his plea was voluntary or knowing. He had no idea. I believe that it even indicated that in the record that he had never shot that gun before. He didn't know if it would actually cause death if he used it in that manner.
But all of that was litigated in a prior PCR, and it went up to the Court of Appeals. The Court of Appeals said, we've reviewed the whole record, there was a factual basis. And now you're saying, no, there wasn't a factual basis.
Right,
so
and that's
that
not the basis.
gets back to 822.8, right?
And that's not the basis as to why we're here today, and I do understand that. But he was never allowed the opportunity to litigate whether or not this weapon was a deadly weapon. That's what I keep going back to.
The basis of Schmidt was that we don't want people who didn't commit a crime commit any crime to be in jail because they plead guilty because of forced confessions or bad evidence or some other reason. Your guy isn't the guy who didn't commit any crime. It's just the degree of the crime your guy committed, and I don't know how he gets the benefit of Schmidt. If it's a crime he would have been charged with lesser included, and you add on top of it the prior PCR, I don't know where you get anywhere with it.
I would quote several statements from Schmidt. Punishment should fit the crime. The crime he committed was not robbery in the first degree, but that's what he is punished for.
You know the record way better than I do, especially the genesis of the case, the criminal case. You don't need to go into great detail, but how many counts was he charged? Do you know in the trial information?
I believe there were several. I
Okay.
don't recall the number.
And up to the point of plea, were they still live charges?
I believe so.
So would I be correct to assume this may not have been an official Alford plea, but there were some concessions made, maybe benefit of the bargain, some of that language may have been used at sentencing?
I don't believe that language was used. I do believe, obviously, that was part of the plea agreement.
Were there other felonies that were disposed of
Yes.
in exchange for this plea?
I believe so, and I didn't represent him at the trial, but I do believe that from the record.
As I understand the claim you're presenting, the factual basis claim was decided in the prior post-conviction relief case. And maybe on the merits some way these kind of mesh together, but the claim that you're actually presenting is notwithstanding the factual basis, my client is actually innocent of robbery in the first degree. And whether that's successful or not is a separate issue, but at least as you're presenting it, it is a separate claim than the factual basis claim. Is that right?
Correct.
Okay.
Absolutely correct.
Then let me move on then to Justice Wiggins' question. Let me just ask you, I looked around a fair amount for actual innocence cases involving lesser included offenses. I mean, I understand exactly what your argument is. I didn't find much authority to support your position. In fact, I would say that I found no authority to support your position. Now, that doesn't mean you're not right, but I ask you, did you find any authority
Unfortunately,
for lesser included offenses? I mean, all the statutes that I looked at and the cases I found a dozen or more, I looked at more, they all stood for the proposition that Justice Wiggins is advancing, and that is actual innocence requires complete innocence, and you don't make that claim today.
Correct, and I think you're correct in your research too. I was unable to find any real precedent regarding our position on actual innocence. But I would submit that this court can make that finding today, can make that ruling based on Schmidt. Again, I go back to the several different quotes throughout that ruling.
But your client pled guilty to avoid maybe consecutive sentences, maybe to avoid some other problems. It's not the Schmidt case where we said no crime at all was committed by this person. And you don't see the difference in that.
And I don't know that the Schmidt case said that. The Schmidt case said remand so that we can find that question out, so that we can get that answer.
Schmidt case is remanded to explore that affidavit, but it says absolute innocence of all crimes charged. That was the test in Schmidt, all crimes charged, and he was charged with these lesser included charges under our law, and he's not innocent of those.
Then I would ask this court to expand that definition of actual innocence and allow this case to be remanded so that the district court can explore in a PCR proceeding whether or not he's actually innocent of the crime that he was convicted of.
Let's play that out. Imagine that on going back. Do you envision seeing very many offers being made by the state anymore in a situation like this? Or are we going to have a squelching and chilling effect?
I don't know, but
Well, common sense. What do you think? Would you agree with me that there are often deals cut, charges dismissed, pleas made that are benefiting of the defendant and prevent a trial from going? Do you think they will continue to do that at the same rate if this is the message that is sent?
they may not. But what was done here wasn't right.
You're changing Schmidt. You know, Schmidt says actual innocence of all crimes charged. You want to say actual innocence of all crimes convicted. And that's not what Schmidt said.
That's what I'm asking the court to expand it to.
But one example, I mean, this would further undermine the finality of guilty pleas, where the state gave up the chance back then to prove its case. And one of the, I mean, here we have a key witness, Leonard Boswell, is deceased now in the interim. If he had gone to trial, and he could have testified live. I mean, I'm resistant to the idea of further undermining guilty pleas. Can you help me persuade me to get over that reluctance? Again,
I would ask the court to look at the disparity in the sentencing in a case like this. For example, if it were a case where, let's say there was a planting of evidence. If there was a police officer that planted a pound of marijuana, but the defendant had an ounce of marijuana, and he pled guilty not knowing that it had been planted, and later finds out he's innocent of that higher charge.
That'd be a due process claim.
That's a lot better case than yours, too, don't you think?
That's a different case than this. It's a due process claim.
I mean, if it had gone to trial, the state has experts that would have testified and have in other cases that a BB gun shoots somebody in the eye and it can be fatal. It can be a deadly weapon, and that's one way this would have played out.
And that's how I believe it should play out. I believe that they could have the war of the experts in the PCR proceeding, but let him have that opportunity.
That's kind of my issue with this, is that you're really not even asserting an actual innocence claim. I mean, you're not saying your client is innocent. He's saying, I might be able to generate a fact question on the issue of whether or not this is dangerous. This is a dangerous weapon, right? I mean, really, you're just saying, I should have gone to trial.
Well, perhaps, but yes, I am saying. Right. But he is innocent. We believe he is innocent of robbery in the first degree.
I'm going to boomerang you down on this end again. You said just a moment ago he should have had that opportunity when one of the justices commented on experts. I think it was Justice Waterman. But wasn't it your client who put the kibosh on that process? Your client's the one that entered into a plea and stopped that trial train from going down the track. So now you're saying that he was denied an opportunity?
He was denied the opportunity in his second PCR proceeding, which brought us here today. And that's when they made the request for the ability to present evidence through an expert as to whether or not this weapon was a deadly weapon.
Here, I agree with you that plea bargains are not sacrosanct. It's not lit on the box. They're coerced, and the literature is full of it, particularly younger people, particularly people that are mentally challenged, et cetera, et cetera. So I'm not in the lid on the box camp at all. But there's a reason for the lesser included offense notion, and that is these claims are often stale. This is a stale claim, I mean, comparatively. I mean, the passage of time. It makes it very difficult to retry cases. It makes it difficult to put the omelet back together on a multi-count plea. So in order to have the actual innocence claim, it looks like the majority of cases are saying that lesser included offenses have to be off the table because we can't ask the state to retry the lesser offenses. And we don't know, in your case, the plea bargain, we don't know, I mean, we can't reconstruct the plea bargain. And that strikes me as a rationale for actual innocence requiring that at least lesser included offenses be off the table.
I believe that the majority of those cases were all civil cases, cases where there were wrongful convictions, and the question was whether or not the wrongfully convicted defendant in that case should be awarded monetary damages. I think we need to do better than that in these kinds of cases. In the criminal cases where someone is facing 25 years in prison. I see my time is about up, unless there's any other questions. Thank you.
Ms. Siebrecht, thank you as well. Mr. Ogden.
I'd like to take just a minute and address Justice Christensen's question about the original charges in the case, which were live at the time of the plea. The defendant was charged with 1 count of first-degree burglary, 3 counts of first-degree robbery, 1 count of assault while participating in a felony, and 1 count of going armed with intent. He admitted that the minutes of testimony were true in the plea colloquy, and even without the dangerous weapon, the minutes of testimony would provide a sufficient factual basis for 5 of those 6 felonies, second-degree robberies, burglary in the first degree, assault while participating in a felony. You add those up, you get 60 years. Unless the court has additional questions for me, I will stand on my principal argument.
I wanted to just clarify, it was not an Alford plea, correct? You said he actually, and was there any comment made during sentencing such as benefit of the bargain? Do you know?
I don't know that there was any specific comment like that, but the other charges were dismissed pursuant to the plea agreement between the state.
If there had been those comments made by the defendant at the time of sentencing, benefit of the bargain, is that any argument for waiver of later challenging the issue?
Yes, I think so.
I have one final question for you. Would you concede here that the actual innocence claim, although related, is somewhat distinct from the factual basis argument that was made in the prior post-conviction relief?
I agree with that, and I think that that's where the error preservation in this case got a little bit complicated because the claim somewhat morphed over the course of the litigation, and one of the complicating factors in this case was that the Schmidt case was actually not decided until the case was pending on appeal. So it did sort of shift over time. If you just look at his petition, it's a factual basis claim. Virtually identical, but as I think I conceded in my brief, through the 1.904 motion, it did kind of shift into more of that actual innocence realm.
At least as presented on appeal, it's a
Right.
different claim than a factual basis claim.
Yes, I agree. Those 2 claims are different. Okay. Thank you.
Thank you, Mr. Ogden. Ms. Siebrecht, thank you again. The case of Dewberry versus State is now submitted. The bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.